Hi, today we're talking about what the main stages of a civil action are before it goes to trial. There are a few stages between filing the pleadings and the trial starting in a civil case. During the pre-trial stage, this is also called the interlocutory stage, both parties must follow the criteria stated in the rules of court. For example, those relating to giving enough details about your case, the gathering and exchange of documents that are important and relevant to the case, this is called discovery, and the preparation and exchange of witness statements by way of written documents called affidavits. During the preparation of the case for trial, during the pre-trial stage, both parties can submit interlocutory applications to the court to help them prepare their case. Interlocutory applications are requests made to the court to make a temporary or provisional decision on issues during the intermediate stage between the start and the end of the case. Some examples of common interlocutory applications include an application for default judgment. This is where, if you are the plaintiff, you apply for judgment without a trial on the basis that the defendant whom you are suing did not appear or submit and serve his defense. You can also make an application for the amendment of documents filed, such as the statement of claim, the defense, or the reply, in relation to the matter in dispute. And you can also make an application for discovery of documents. Through this process, the court orders a person to disclose or to give up certain relevant documents in his possession or in his power or under his control to the other person. You can also make an application for something called further and better particulars. Through this process, the court orders a person to provide more details in his pleading so that the other person can better understand what he needs to establish at the trial. An application for summary judgment can also be made, and this is where the plaintiff applies for judgment without trial on the basis that the defendant has no real challenge or case to mount at the trial. You can also make an application for striking out parts of the case, such as the defendant applying for some parts or the entirety of the plaintiff's claim to be struck out on the basis that there are no reasonable causes of action disclosed and the action is trivial or is intended to annoy or to abuse the court process. Interlocutory applications can be started by filing something called a summons together with an affidavit, which is a sworn document to support your application. The summons is a document that states that the parties and also the order and the person who wants to obtain from the court and the grounds of application for the order. The affidavits are documents that states the facts which a person seeks to rely on or in support of his application. The affidavit must be attested to and signed before someone called the Commissioner for Oaths. So, there you have it, some very basic information on how you defend a civil claim without a lawyer. Thanks for watching. Bye-bye.